Welcome to Inside Rosenberg Estis. My name is George Shea, and in this episode, we're going to explore how New York City's real estate and marijuana markets intersect, providing insight for owners, brokers, and managing agents. To shed light on this issue, we have Adam Lindenbaum, member, and Harris Davidson, associate with Rosenberg Estis. Adam and Harris recently appeared in The Real Deal, providing a broad overview on the issue, so we'll be able to get into a lot of the details. Adam, why don't you introduce yourself, and perhaps you can give us the lay of the land on how illegal uses were treated prior to the legalization of cannabis.
Sure. Thanks, George. I've been a member at R&E in the litigation department for over 10 years and practicing in other firms for about 10 years before that. And we have seen the RPAPL 715 deals with illegal use and immoral use of real estate. So if you were an owner, and typically this section was geared towards drugs and prostitution, it's colloquially known as the Bawdy House Law. You would be given a notice by the district attorney and told that landlord, you must commence illegal use holdover proceedings against your tenant because they have violated the law. That section of law talks about sections of the penal code and infractions of those penal codes, and convictions under those penal codes are presumptive evidence that the tenant is engaged in that illegal or immoral use, and that's an actionable, evictable offense, and that if the landlord doesn't commence such a proceeding or proceed diligently to completion, the DA can take over that proceeding and make the landlord a respondent in those eviction proceedings. So there have been cases over the years that I've been involved in that have tried to expand the scope of what they call the Bawdy House Law. There was a case where they tried to extend it to white collar crime. There were some legs with that in the beginning, but eventually that was dismissed, holding that it didn't hold up. And then I was personally involved with some cases with synthetic marijuana, which were not illegal under the penal code because they were invented so quickly with these synthetic materials, but they were against the Department of Health regulations, not illegal, but violations of administrative code. I had tried to pursue those kinds of evictions, but the courts were not looking at those kinds of cases favorably. So fast forward to where we are now with cannabis, which was legalized in 2021 by the New York State legislature. The DA was initially sending letters to owners under the RPAPL 715 saying, you're engaged in illegal activity. But then they said, well, no, it's not illegal anymore. Well, you're selling it without a license. That may be a violation of the cannabis laws, but it's not illegal. And so rather than fight that fight, what happened was a series of new laws that the legislature and the New York City council enacted just recently. But I'll let Harris talk about that big change that happened in 2021.
I want to introduce myself to our listeners. My name is Harris Davidson. I'm an associate at Rosenberg Estis in the litigation department. And I come to this field by way as a former prosecutor in Miami-Dade County, where I prosecuted more than my fair share of drug offenses: marijuana, cocaine, heroin, fentanyl. I've seen it all. And now I'm here trying to put that prior experience to good use for R&E's landlord clients. Lo and behold, Adam had a few clients that were coming across these issues with the illegal, unlicensed smoke shops. And I've been here and learning the laws as they've been changing in New York. As Adam said, there was a big change in 2021. Everyone who's in the city is probably aware just by walking out on the sidewalk and smelling, you can know that there's a difference. And what happened was that the state passed the Marijuana Legalization Act that effectively decriminalized marijuana for folks who possess it in quantities that are lower than a sale or a distribution amount. For the average person, that's how the law has affected them. So you can no longer be arrested and taken to jail for having weed in your pocket. If you're on the sidewalk, you're in the subway, wherever, you can go to Washington Square Park and smell the results of how that law has impacted everyday New Yorkers. For folks in our world, in the retail world, the real estate world, and the store world, the way that this law has impacted people is that it created what's called the Office of Cannabis Management. And the office was charged with developing and implementing regulations for how marijuana was going to be sold legally in New York. So you have the use that's been decriminalized and it's now legal, but then the question is, how do folks who are using it, on the other hand, get legal marijuana? And that's the place where we find ourselves in. Office of Cannabis Management, called OCM, was a little bit slow in rolling out their regulations, in part because this is a pretty new field. They were able to look, I think, to some part in what other states that had come before had done, like Colorado. But New York is different. New York is always going to be a little bit more complex than other states. And there are a lot of interested stakeholders as well that needed to be heard by OCM. So you have this brew in the state of cannabis is now effectively decriminalized and legal if you have an individual use amount. So no one's afraid of getting arrested, but you don't have an effective way yet of legally selling it because the OCM was not moving quickly enough with issuing these licenses and implementing the rules and procedures that are needed to legally sell weed. And, this is where we find ourselves, where our clients, our firm's clients, as landlords, start getting tenants that are not quite following the law, that are selling unlicensed marijuana.
And I understand that there was a Hudson Valley judge who issued a TRO that temporarily halted the licensing process. What's the status of that now? Are no licenses being issued right now, or what's the status?
It's a great question, George. The licensing has come in fits and starts. The cannabis law that was passed in 2021 required the first license to be issued by the end of 2022. So there were, I believe, 2 or 3 licenses that were issued right at the end of the year. There have been a few more that have been issued. There have been a few, temporary licenses that have been issued, and it's slowly started to come. One of the requirements that the OCM decided that they were going to, put into their regulations is that in order to get a license, you needed to have some type of justice-involved ownership. In practice, what that has meant is that people who were previously incarcerated for felony possession of marijuana have been given preference for obtaining these licenses to legally distribute. That, it's an honorable thing for them to want to do, for OCM to want to do. You can understand politically why that was pushed forward. This Hudson Valley case is a group of disabled U.S. military veterans who believe that they should be given preference. These are folks who are not prior convicted felons for marijuana, but who believe that because of their combat trauma experience, use of marijuana for PTSD related issues, that they should be given preference. And they convinced the judge in Hudson Valley that the licensing process, as outlined by the OCM, deprived them of their due process rights. That case, as we last checked, is still ongoing. But OCM is going to be able to pick up with the licensing as soon as it's resolved. There's really not an issue in terms of the ability to issue licenses. It's more of just a timing thing, which gets us back to the problem that we've been in for the past few years of legal marijuana, but not enough legal places to sell it.
Well, and here's I'm a resident of New York City, and I certainly have smelled it on the street everywhere. My question is, it seems to me that this is being sold in all variety of locations, and I suspect many of those selling marijuana don't have licenses. And so, Adam, what's the landscape there? Is there any sense on how many of the shops selling it are not technically legal? And then what's the problem with renting to a cannabis shop if you're a property owner?
I mean, the vast majority of the retail locations that you see, and the estimate of that number is wide ranging about, but in the thousands, are not licensed. And it's created a huge problem. And there was, this perfect void in the retail landscape because in the 1 year or 2 years since cannabis was legalized, 1 year preceding to that, we had the onset of COVID. And with that was the decimation of the retail landscape in New York, creating so many vacancies. So here you have what appeared on the surface to be a perfect fill of that void. You had uh, a decriminalized substance, a high demand for it, and owners who, missed out on a year or two of revenue from their retail spaces. And it was a perfect plug to fit in there. And that's why we have the number that we have, because the void was there. And this business moved in to fill it, seemingly with little downside at the time, not aware of what was to come. But there were problems. The marijuana is still a federally controlled substance. So notwithstanding that New York has legalized it, and I believe at least 20 other states have, at this point, it remains a controlled substance under federal law, which creates problems with insurance companies, creates problems with national banks, banks that are conducting interstate commerce. And so, you see these shops proliferating in the Class B buildings, the buildings on the side streets, or single-use retail shop buildings, not in Class A buildings. And look, this isn't a wildly popular decision. New Yorkers can't agree on anything, it seems. There are definitely positive parts, things about marijuana being legalized. It alleviates the suffering of many people. And some people believe that it's good, but others believe that it attracts a nuisance, and there's more smoke and there's more throngs of people crowding the sidewalks. And we don't have to debate here whether it's a good thing or not. But, people started to complain once the proliferation of these shops, came to be, when that COVID void was filled.
But from the perspective of a property owner, it seems to me that there are like a web of different laws, right? You have the federal laws, you have the state law, and then you have new statutes coming out. And then, Adam, I just following up on what you just did, I understand Manhattan District Attorney Alvin Bragg put out a letter mentioning illegal trade. So there seems to be some confusion. I don't fully understand the letter on RPAPL 715-1. Like, what was that?
Right. So that original statute that has been on the books as part of the RPAPL for decades, they realized shortly after that letter was issued that the concept of legalized but unlicensed cannabis couldn't be wedged into the text of that statute as was written. And I think the various lawmaking bodies in the state and the city realized that additional steps needed to be made in response to the complaints that people were making as a result of the proliferation of cannabis shops. So that's what that is the new laws that we've seen enacted earlier this year.
Right. And so, Harris, you're talking, Adam, there about the new statutes. Is that right? Like, Harris, why don't you explain some of the new statutes and how they're affecting things?
Definitely. I'd love to, George. So we've got three sets of statutes, really, that we're talking about, two of which were passed the state level in Albany in May, and one of which was passed by the New York City Council in July of 2023. All three are basically going after the same problem that we've been talking about of landlords renting to tenants that are operating unlicensed smoke shops. Prior to the passage of these laws, city and state enforcement agencies had been targeting the tenants, who are really, we would argue, the ones who bear the ultimate liability and responsibility here. The problem with targeting these tenants, of course, is that a lot of them are fly-by-night shops that will receive an order to shut down, and they'll shut down and disappear. And there's no way for the city to ever stop the unlicensed sale of marijuana, because the proprietors of these stores will just open up for the next vacant space that allows them to come in. It turns into a game of whack-a-mole. So these laws are intended to find a deeper pocket than the tenant's pocket, which unfortunately for a lot of Rosenberg and Estes' clients means them, the landlords, the property owners, the managing agents, the people who are the ones who are signing the leases. So RPAPL 715A authorizes state enforcement agencies to commence eviction proceedings under the framework of the original PAPL 715, as Adam had said. But instead of just being for illegal use, it's now clarified that illegal use includes violations of penal law section 222 and violations of cannabis law article 6, which are the specific laws governing how you need to be licensed and how you can only have a certain quantifiable amount if you're going to be distributing it for profit. So the mechanism of this new law 715A is that, the enforcement agencies, in addition to going after the tenants, can go after landlords. So if a landlord receives a notice that their tenant is violating these two underlying cannabis laws, and the landlord does not act expediently to take steps to remove the tenant from the premises, the city or state enforcement agencies can put the landlord on the same side of the V in a case in New York Civil Court, and will treat the landlord as if they're in cahoots with the tenant. This is obviously very problematic for landlords who are just trying to cover the rent rolls and are not involved in the sale of marijuana. They're just accepting funds on a monthly basis from a tenant. And 715A, the financial penalties are steep. It says that if a landlord is found to have been knowingly renting and accepting rent to a unlicensed cannabis distributor, that they may be liable to pay in a fine 3 times the amount of that rent.
So I want to dig in on that a little. So the burden of this has been now placed squarely on the shoulders of the property owner. They can be fined. They're sort of alongside their tenant, whether or not they had anything to do with it. What is the timing? Like, what is expeditious in terms of them acting on this? And have there been cases where they've taken action against the property owner? I mean, clearly most property owners would now have a sense that this is an issue, but I can see some people being caught surprised.
Yes, and that's the question that we're getting from all of our clients. How quickly do I need to act? What do I need to do in order to make sure that I'm not penalized? And the answer is, like all good legal questions, it depends. The statute says that landlords must act diligently and in good faith. In other points, it says that they have 5 days to respond to a notice that's been duly given. But look, in real life, the court system doesn't act that quickly. So if a landlord receives a notice and they don't respond within 5 days, are they going to be held financially responsible for the conduct of their tenant? Probably not. So the advice that we've been giving to landlords is to move as quickly as possible, but to know that you're still dealing with the court system at the end of the day. And the court systems are inherently slow and inherently not expeditious.
But to be clear, this is being enforced across the city. Is that right?
Well, what we're seeing is a little bit of a smattering of a bunch of things, because Harris talked about RPAPL 715A, which is on the state level. There's a corresponding section in the cannabis law, 16A, which gives the state authority to sue landlords for preliminary injunctions, closure orders, TROs, and put a notice of pendency on property to sue not just the landlord and the tenant, but the real estate itself, to attach the property in the litigation. And then there's a local law, Local Law 107, which talks about upon receiving such notice, monetary penalties against the landlord in substantial amounts, $5,000 for the first instance and $10,000 thereafter. So, there's this web of both state and local laws. And in connection with that, there are also numerous enforcement agencies authorized to act. We have seen, the Attorney General is authorized to act. The Office of Cannabis Management is authorized to act. The NYPD and the DA in the city are authorized to act. And we've also seen instances where the Department of Taxation and Finance, in connection with the Office of Cannabis Management, have acted and piggybacked off one another because of the tax implications and burdens upon the license sale of cannabis. And so the clear path to enforcing this one perceived wrong of sale of unlicensed cannabis, it's not clear how it's being enforced in Manhattan, where the majority of our practice is, and in the outer boroughs, and outside of New York City. So we've seen OCM act within the city. And then we have, that was in one Lower East Side client. And then we have another client about 5 blocks away where the NYPD is acting. And it's unclear to us exactly which authorized governmental agency is going to act, or whether they're all going to act. And in what proceedings, whether they're going to demand the eviction proceeding of RPAPL 715A. Are they going to be content to just issue administrative fines and collect the cash through an environmental control board violation? And we've also seen, which is another remedy on the books, the public nuisance abatement actions, where the Corporation Counsel of New York City, in connection with the NYPD, will just run to court and get a TRO and shut these businesses down immediately. It's a very quick, expedient remedy, which has also been on the books for a long time, and famously came up with the counterfeit goods in Chinatown, but we've seen applied to the drug context also.
And for both of you, it strikes me, and this might not be the case, that the landlord has liability to the city and the state, but also could run afoul of its tenant, depending on a lease or depending on what the way the state is acting. I'm not sure of that. But one way or another, the landlords obviously have a lot of concerns here. What would you be advising a property owner who has a cannabis seller as a tenant or is considering one?
I mean, first of all, make sure your lease covers you. And if you're going to enter into a lease, make sure that compliance with laws, prohibited uses are clearly defined. It's not just, prohibiting the sale of marijuana, but making sure that it's licensed, encouraging existing tenants to get licensed before these agencies come knocking and issuing notices of violation. And just making sure that you stay one step ahead of the game where you're being targeted for penalties for knowing violations. And in the languages of the leases and the uncertainties of litigation, we haven't received too many of these because this is all so new, but I anticipate that we will be able to work things out and give our clients breathing room, either by prophylactically taking steps to enforce rights under a lease, working with tenants, advising them how they can get licensed, curbing their uses, etc. So, each set of facts is going to be different, but we are encouraging clients to come contact us before the government agencies do.
And Harris, could you tell us more about the notice of pendency? And also, what happens if a sort of any shop that a landlord has as a tenant just begins selling marijuana, a head shop? It could be anything. What's their action then?
So, George, the notice of pendency is important for a lot of our clients because it's one of the things that the Cannabis Law 16A, which is one of the recently passed laws, allows the enforcement agencies to put on the property itself. Unlike RPAPL 715A, Cannabis Law 16A allows the enforcement agency to proceed in rem against the property, regardless of if the tenant or the landlord show up in court to defend the action. If the city or the state agency is able to get relief from a judge and is allowed to place that notice of pendency on the property, it can really cloud the title of the property for a landlord. So if they're trying to refinance or they're thinking about selling, and a broker runs a title report, it will show up that the notice of pendency has been placed as a result of the alleged illegal conduct of a tenant. And in a multi-tenant building, if it's lots of commercial tenants or mixed use with residential, one little issue like that can cause a lot of concern for a landlord. To answer your other question, George, we get clients all the time asking us, how do I know if the tenant is doing this? For most of these cases, it's pretty obvious. They're targeting retail customers on the sidewalk. They have big pot leaf flashing lights and joint signs, and it's intended to bring customers in. These are not secretive stores, at least in our experience as lawyers, and then also people who work and live in Manhattan. Some cases that we've seen, the tenants were originally legitimate. It was a deli, and then because of this change in laws, they decided that they were going to start selling marijuana. It's a lot more profitable than just selling sandwiches. I think the advice that we can give to our landlord clients is, as a result of these new laws that were passed in 2023, they can't turn a blind eye to the conduct of the tenant. Even if the lease says it's a deli, if they know that the tenant is selling marijuana, they could be held responsible for continuing to collect rent after they become aware of that. Clients who know that their tenants are selling and that they don't have licenses, or they're not sure if they have a license, they should speak with their brokers, they should speak with their lawyers, make sure that they're on the right side of the law here. Because the worst thing that could happen is it turns out that the marijuana leaf has been up on the store for a year and a half, and the tenant has been openly selling marijuana for that amount of time. And it's a lot harder for us as the lawyers, for the landlord to say, we had no idea.
Yeah.
The other way, George, that landlords are receiving constructive notice is from complaints from residential tenants who live above these shops.
Right.
We've had clients say, I have residential tenants who want to break their lease because they feel unsafe walking home at night with throngs of people outside the marijuana shop, just lurking around and smoking. And I feel unsafe and I want to break my lease. So besides the disruptions and, the leasing issues that causes, arguably those residential tenants have causes of action for breach of the warranty of habitability, for the landlord failing to provide a safe residence and failing to police its tenants and that tenant's patrons, and failing to enforce the terms of the commercial lease that probably, by the letter of the lease, prohibits that kind of conduct, and from the commercial tenants' customers from causing that kind of nuisance. But by not enforcing it, causing a condition that is dangerous, that's unfit for habitation for the upstairs residential tenants, and that kind of claim raised, say, as a defense to a non-payment proceeding or some other action initiated on behalf of a tenant, or defense initiated on behalf of a tenant, could also put the landlord on constructive notice.
What would your final word be for property owners on this subject?
I think that the most important thing is to be diligent and to always be aware of what's happening in your space. So if you have an existing tenant that you're concerned is violating the law, make sure that you're staying on top of that tenant. Reach out to your lawyer if you have questions as to whether the tenant is licensed or not, and if they're violating their lease or not. And if you're looking to rent new space to a new tenant make sure as well that you've spoken with your lawyer to guarantee that the lease has the provisions that will protect you in the event that the tenant decides that they're going to switch their business model and start selling cannabis.
Okay. Thank you both for your insight on this, and contact information for Adam and Harris is included with this podcast. Don't hesitate to call if you're looking into this or if you have any questions, and we thank everybody.